Court does call the case. People versus Benjamin Detlefs. Oh.
The courtroom opens with Judge Simpson calling the case. But notice the immediate tension. We're not even 30 seconds in, and already confusion brews around Benjamin's custody status. The defense seems blindsided by his placement in solitary, a huge red flag in any proceeding. Solitary confinement is typically reserved for disciplinary reasons, or when an inmate poses safety risks. So why is Benjamin here? Was it miscommunication or something more serious? Judge Simpson wastes no time cutting through the haze, pushing the attorneys for clarity. This is where cases begin to snowball. An adjournment request, confusion about bond, and multiple overlapping charges. Right from the start, we see how chaotic overlapping court dockets can become, especially when mental health issues are in play. For you watching, ask yourself, does this sound like a system protecting due process, or a defendant getting lost in the shuffle? Stay locked in, because this mess is only getting deeper.
Stephanie Cannon on behalf of Mr. Detlef.
Detlef, can you state your name?
Yes, Benjamin Detlefs here for the court, Your Honor.
All right, thank you.
Thank you.
Thank you. Your Honor, we are asking for an adjournment of this matter. And I'm surprised to see him in the solitary, Your Honor. When I spoke to him yesterday, he was doing pretty good.
All right, you want? I'll adjourn it for you.
February 20th.
Hearing will be adjourned February 6th.
February 6th.
February 20th, he's been called to stand trial in his other cases.
He is?
Yeah.
Gotcha. Thank you.
Your Honor, I would like to, and I see that he's being held right now, but I would like to address bond in this matter. So my client was found not competent.
Hold on. Is he being held on the other matter? Okay, silence. That means I asked a good question.
You asked a really good question, Your Honor.
Yes, he is held on the other matter until February 20th on a $1,000 bond. The bond in this case is $100.
Here's where things heat up. The defense tries to argue bond, but Judge Simpson immediately points out the elephant in the room. Benjamin is already being held on another case. This is a textbook example of how bond isn't just about the case at hand. Judges must consider the bigger picture, prior cases, overlapping charges, and even jailhouse conduct. In Benjamin's situation, bond in this case is practically irrelevant if another case already locks him in until February. The defense still pushes, hoping to shave off restrictions, but Simpson is firm. And let's be real, can you blame him? If someone racks up multiple cases while deemed incompetent, releasing them early could be reckless. Question for you, should judges allow bond debates when a defendant is already held elsewhere, or is it just wasting court time?
The bogus assault. It is PCC.
Your Honor, I'm still going to address bond, and if the court would allow me to, please.
Yeah, go for it.
And I understand the court's position here, but my client was,
What do you mean you understand my position? I'm saying he's held on another case, so I don't know what you want me to do.
Your Honor, I want to get this. Will the court please just indulge me for a moment? I want to address bond.
Apparently, I don't have a choice. Go ahead.
The reason why he was being held in the first place was on the case out of the 15th, where he had been found not competent. And they did a involuntary commitment order, but they found him not competent and the case was dismissed. And since then, my client has just been held and held and held and held. And while he's been held because he's not competent, because he has mental health issues, he's collecting these cases. Your Honor, I don't understand how he was still held after the case from the 15th District Court was dismissed.
This is a bombshell. The defense reveals Benjamin has been piling up cases while in custody, largely because of his mental health struggles. Think about the cycle. He's found incompetent, dismissed in one case but stays locked up and racks up new charges, including assaults committed inside jail. This creates a vicious loop where jail becomes both punishment and the breeding ground for more charges. Judge Simpson quickly zeroes in on the September jail assault, explaining why Benjamin wasn't released despite dismissal in another case. It's a harsh reality check. For viewers, should someone with proven mental health incompetency be trapped in this revolving door of charges, or should the system focus on treatment instead of endless prosecution? That's the question tearing through this exchange.
I don't know. But he's held on another matter at this point. Right? What is that other matter?
Hold on, that's a solid case. Which case file are you talking about? Because the FA case that he's in custody is a 15th case that hasn't been dismissed. Do you have a case file for the dismissed 15th case number?
Your Honor, I actually put it on my notice to request the adjournment.
Is it
24-1311 SM. That would not be a felony case.
That's the case he's been going. That's the only one other.
That's not the case he's being held on.
Okay.
That's held on is 24 F5 5228.
Thank you, Your Honor. And I'll look into that as well. But again,
And that's an assault that he committed in the jail before his 15th case was dismissed. So he was in custody on the 15th case that you're now saying has been dismissed.
has been dismissed, yes.
He assaulted somebody in the jail before that 15th case was dismissed, and he is in custody for that September assault.
Which may explain why he wasn't released.
Thank you, Your Honor.
Motion for bond reduction denied. Bond will continue. Did I give a date already?
Thank you, Your Honor.
I'll adjourn the matter to February 6th. Or February 20th, I'm sorry, 2025, 9 a.m.
Bond denied. Case adjourned. Judge Simpson doesn't flinch here. Despite the defense's passionate plea, he prioritizes public safety and the pending assault case. This is classic Simpson. Concise, decisive, and unwilling to indulge what he sees as courtroom theatrics. For defendants like Benjamin, this is devastating. But for the court, it's pragmatic. Judges often rely on a pattern of past behavior more than promises of good conduct. What's striking is how casually the adjournment is granted, as if moving this human life around the calendar is routine business. And in many ways, it is. Courtrooms are conveyor belts, and Benjamin just got placed on hold. Would you have ruled differently if you were in Simpson's chair, or does this decision make sense given Benjamin's record?
Go along with this other case, bond will continue.
Ready, Judge. Torshell Feaster, Assistant Public Defender, appearing on behalf of Mr. Driscoll. Mr. Driscoll is approaching the podium, Your Honor. State your name for the record.
My name is Jeremiah David Driscoll.
Thank you, sir.
Thank you, Judge. Mr. Driscoll would very much like to get this matter resolved as quickly as possible. I spoke to Ms. Zinda about it. At this time, there isn't an offer yet. She's had to speak to the victim in this case.
How did your conversation with Ms. Indigo?
Well,
Did she just
pleasant.
repeat the police report to you?
No,
No, I just thought I'd
she didn't
ask.
have to, Judge.
I just thought I'd ask, because that's what I'm here.
Oh, no, she didn't.
Oh, okay. All right, that's what I thought. I
She was
didn't
very
think she
pleasant.
did that. I just thought I'd ask.
So my client wants to get it resolved as quickly as possible. He's
All
asking
right.
for a 1 week adjournment if the court granted, but I told him the court would.
Are you gonna be able to get it done in 1 week?
She'll talk to the victim, I'm sure, within a week and let me know if they're.
Oh, that was cordial.
Thank you, Ms.
And
Zinni.
again, it had nothing to do with the police report. The 30th.
Thank you, Judge. Next week. And I do not have a bond argument. Thank you.
What'd you say?
I do not have a bond argument.
You don't? Okay,
Oh,
good.
oh, now he does.
He does now?
Yes, Judge. My client is asking Your Honor to consider a personal bond in this matter. He says he does not have a violent record and he would like to be able to be released. But we talked about this in holding. I told him if you gave him a 1 week adjournment, you're unlikely to change the bond. But he is asking that you change it anyway.
Okay, now here we go. Miss Enda.
Given the defendant's history, he has a DV from 05 and multiple, or a dismissed DV, child abuse fourth, and 2 AMVs. In this case, they had been dating 2 years and the victim was 3 months pregnant with his child. He was upset that she wasn't getting an abortion, stated, "You're not gonna get rid of that baby," and pulled out a folding knife on her.
This is the gut punch moment. The prosecutor lays out chilling allegations, domestic violence threats involving a knife, physical assaults, and a pregnant victim caught in the middle. Suddenly, any talk of bond reduction feels absurd. The emotional stakes skyrocket. Simpson listens, almost letting the facts speak for themselves. For the audience, this is where legal reality and human tragedy collide. Domestic violence with a pregnant partner is among the most aggravating factors in sentencing and bond considerations. And here, the defendant even called 911 to spin the story, showing manipulative intent. The real shocker: the bond was already relatively low. The prosecutor admits surprise it wasn't higher. Simpson doesn't budge though. He leaves it where it is, but his tone shows he's not buying any defense narrative. This is courtroom gravity. No jokes, no theatrics, just raw stakes.
She went to the bathroom, locked the door, and called 911. She then attempted to leave the store that she was working at, grabbed her by the throat, he then headbutted her. He then began to demand that she give him her phone as she was calling 911, and was pulling her across the floor of the store by her hair before fleeing. Immediately after fleeing, he then called 911 himself to say she was making a false report and that he was in Detroit, when in reality, it was shown that he was in Ipsy. Her dispatch is at House of Liquor. Do you have facts of this case, Your Honor?
Nothing conditional, Your Honor.
I'm surprised this bond is actually so low, but I'll leave it where it is at this point in time. Motion for bond reduction is denied.
Thank you, Judge.
Bond will.
And on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Bankhead. Can you state your name, sir?
Elon Bankhead.
Thank you.
Your Honor, we are waiting to receive and review media discovery, so I'm going to need a adjournment of the probable cause conference, please.
All right. How much time have you received it as of yet? Is that a green sheet?
It is a green sheet. Not yet. Ms. Zinda believes that she released something to us. We don't have it on our end. I don't know if it's our end or their end, but we are in communication about it. And we're going to.
Ms. Zinda said she did it, then it's your end.
I believe that as well, Your
Just
Honor.
saying.
Checking to make sure it'll be released. We have it, it'll be released. Right.
Gotcha.
And just address bond, Your Honor. Appropriate.
Yes.
Yes, Mr. Bankhead would like me to ask for a reduction in bond, Your Honor.
Hold on one moment.
Sure.
So you're gonna get that released. How much time are you gonna need to review that?
I'd ask for the shortest possible adjournment, Your Honor. Mr. Bankhead's very motivated.
Probable cause conference, January 30th, 2025, 9 a.m. All right, go ahead. Bond.
Well, I don't know. Did you have something?
Your Honor, we would be addressing the defendant's phone privileges and be asking that they be revoked. He's making calls to not the victim.
This is where bond violations explode into something bigger. The prosecution presents recorded jail calls of the defendant trying to tamper with witnesses, urging family and friends to pressure the victim into skipping court. That's a major red flag, and it's one of the fastest ways to lose privileges. Simpson wastes no time revoking phone access. This is more than a legal maneuver. It's about protecting the integrity of the case. Courts view tampering attempts as nearly as serious as the original charges. If you're watching, ask yourself, would you trust someone to remain on bond when they're already trying to manipulate the system from behind bars? The drama here isn't just legal, it's human. A desperate defendant pulling strings and a judge slamming the door shut.
But we believe other family members and saying things like, tell her, make sure you know who, don't make sure she don't show up to court. And the more she don't come to court, we good. Other calls, he says, can you tell my mom, make sure you don't come to court, get in contact with Marquisha, the victim. Tell her if she really wants to be with me, go to call the prosecuting attorney, tell her to drop all this expletive. Tell them, do everything she does and she's getting off this. I don't care anymore. If she really wants to be with me, call her and tell her to drop all this. Have great concern in having other people contact the victim and telling her to not come to court to drop the charges.
Your Honor, this is the first I'm hearing of it. I would ask that the court not revoke his phone privileges until I'm able to review the calls.
His bond will continue at this point. Defendant's phone privileges are revoked pending a hearing.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honor. Good afternoon. Good morning, Your Honor. Rob J. Kill on behalf of Mr. Dawson.
Your name, sir?
Messiah Dawson.
Thank you.
Judge, in this matter, I'd like to set an exam in this matter, and if I may address bond.
Is all discovery complete?
I believe so, Your Honor.
What's that? People have their witnesses available February 4th.
Just checking if they have a moment here.
Judge, I have a trial on what Judge Kunke on February 3rd. That's definitely going to go. CFC matter.
February 11th.
No, oh, that'd be fine.
Preliminary examination in person, February 11th, 2025, 9 a.m. in person before Judge.
At this point,
Your
Judge
name, sir?
Simpson is trying to
Dawson.
balance logistics with accountability. The
Judge,
defense
in
paints
this
their
matter, I'd
client
like
as
to set
someone
an
who wants to
exam in this
comply
matter,
but
and
is
if I
tripped
may
up by
address bond.
technicalities,
It's all
late
discovery
arrivals,
complete.
lack of transportation, difficulty accessing testing facilities. It's a sympathetic spin, but Simpson cuts through it with razor
People have their
precision.
witnesses
You either
available
comply
February
or you
4th.
don't. Judges often see this excuse pattern. I tried, but it rarely holds water. Community corrections programs exist to provide flexibility, but the defendant hasn't delivered
Judge,
proof of
I have
compliance.
a trial
Simpson
on
makes it
what Judge
clear
Kunke
alternatives
on
like Detroit
February
testing
3rd, that's
facilities
definitely
will
gonna
be
go.
considered,
CFC
but not
matter.
if it creates another
February
cycle
11th.
of missed
No.
tests. This
Oh,
is a
that'd be
classic
fine.
tension, compassion versus consistency.
Salvo.
Thanks, Your Honor.
Judge, just as to bond, this young man, if you recall, you told him to test. He lives in Detroit. There was some issue of, and I remember this, the court, not you and I discussing that we were going to try and find a testing facility closer to the Detroit area where he was living. That was the issue of him not testing. We would renew that request. I believe that's the only reason that this young man is now in jail, and we would ask for a PR bond. And
Well, I would permit him to test there, but he didn't test. He's got to sign the release. We have no information.
well, Judge, he was trying to test here, get rides up to here. He showed up late. They refused to test him. Quite frankly, I think, and then he just didn't test, but it wasn't because he didn't want to test. I think if you tested him, that he would be clean and that he's willing to follow the court orders if he can get a testing facility in Detroit. I'm just asking if you
Find a testing facility and it meets the approval, you can either get mine or Judge Valvo's signature on it. I don't have a problem with that. And then I'll let Judge Valvo, since it's her case now, set the bond, or if you need to get it before me, I'll deal with it.
So if we find a testing facility, you would
That is approved by community corrections. I do not have a problem. I just want a certain level of testing.
What's that?
We're gonna come on.
And he has to sign a release.
Come on, girl.
He's now saying, Judge, if that he'll get a ride out here, he'd like to be out of jail, obviously.
I know, but we tried that and that didn't work. So which way do you want it? It's either gonna be, he's gonna test here or he's gonna.
Well, if you're gonna make the commitment to test here, you can't fail. Judge, he said he's willing to.
Find,
I didn't
your
finish.
first request was to find a facility. Find a facility that's approved by community corrections. I'll sign the order. You can have Judge Valvo sign the order. I don't have a problem doing that. But I'm not gonna go around in this circle where he doesn't make it out here and then doesn't test, and we're back here doing this again.
Well, if he's selling the court.
I just said what I said. Bond continue.
Thank
Thank
you.
you.
Thank you, Your Honor.
That's
And Your Honor, Joe Simon on behalf of Ms. Mejia, Ms. Teachman.
Isabel Mejia.
This exchange may sound procedural,
Your
but
name, sir?
notice
Well, sorry,
Simpson's
Dawson.
sharp
Thank
wit.
you.
When counsel bungles dates or
Judge, in
fumbles
this matter, I'd like to
logistics,
set an
he wastes
exam in
no
this
time
matter, and
calling
if
it
I may
out,
address bond.
sometimes with
Is all discovery
sarcasm.
complete?
These moments remind us that judges aren't just referees,
What's
they're
that?
personalities shaping the courtroom dynamic. Here, he catches
People have their
inconsistencies
witnesses
with
available
scheduling,
February 4th.
quipping about attorneys picking days in the past. That blend of humor and impatience keeps the courtroom in check, but also lightens tension in a docket full of heavy cases. For viewers, this
Judge,
shows how
I
much
have
power
a
courtroom
trial
demeanor
on with
holds.
Judge
A witty
Kuhnke
judge
on
might diffuse tension,
February 3rd.
but
That's
also
definitely gonna
risks
go.
appearing
CFC matter.
dismissive. Do you prefer
February
a judge
11th?
who runs
No,
proceedings with
oh,
humor and
that'd be fine.
sarcasm, or one who sticks to pure formality? That's the style debate at play.
Preliminary-
But in this matter, we're requesting a preliminary examination. The discovery has been completed. And both the parties are requesting if the court would set it for next week, Tuesday, the 28th.
Why?
Next week is totally fine. I could perhaps suggest it to Mr. Simon. If he didn't put it on me, then he should have.
See, the part that the court looked at me last night was the part that said refrain from all offensive personality.
Absolutely. That's you. Found you right in the audience. That was the part. I was trying not to say that out loud.
So I took the court's cue. That's why I didn't put that all on Ms. Hughes just now. I can be coached.
Okay, you weren't offensive to her, but you are being to me. So it's just not working for you, Simon. This is like the second time Hughes has like tried to pick a day in the past 2 weeks. Isn't that right? Yeah, she's going on that list. What date is that? 28th. January 28th, 2025, 9 a.m. in person before Judge Washington. Bond will continue.
Thank you, Your Honor.
I get to see him 2 days in a row. I'll see you tomorrow, right?
Yep. I just got back last night.
Figured. Court calls the case, People versus Warren Abbott.
Andrew Childers appearing on behalf of the people.
Stephanie Cannon on behalf of Mr. Abbott, who's appearing to my right. Mr. Abbott, could you please state your name for the record?
Warren Abbott.
That was a lot of walking. Go ahead. No, it's all right. Go on.
Thank you, Your Honor. Today is the date and time set for his probable cause conference. We're going to ask for adjournment in this matter. We would like to see if my client qualifies for mental health court.
This is an important pivot. Defense requests referral to mental health court, signaling the defendant may not be best served by traditional prosecution. Mental health courts aim to address root causes, therapy, medication compliance, structured monitoring, instead of revolving jail doors. Simpson shows openness, adjourning to allow paperwork, but note his skepticism. These specialized courts save money and reduce recidivism, but they also require strict compliance. A defendant who can't even show up consistently is a risky candidate, and yet ignoring mental health factors can worsen long-term outcomes. Here's the crux: balancing public safety with rehabilitation. For the audience, consider this. If someone with severe mental health issues commits repeated offenses, should the system emphasize treatment or punishment? This case captures that tension in real time.
All right, you know their timing at this point. I don't have the referral form, so.
I spoke to my client last night about whether or not he'd be willing to do this, and he indicated yes, Your Honor. So I'll get the paperwork filed today. Wait.
All right, probable cause conference, February 13th, 2025, 9 a.m. Bond continued.
9 a.m. Your Honor, as far as bond goes, my client would like the opportunity to be released. He did miss one day for this court. Your Honor, he is kind of at the mercy of somebody else at that point in time, and he's homeless, so he didn't get the notice. It's my understanding that the notice was, that person indicated after the time that he should be here. My client, he will.
How do you come back into custody?
Your Honor, I think didn't you walk up to a police officer while you were at the Delana Center?
I'm not, I don't remember.
My client also has mental health needs and some cognitive issues, Your Honor.
I don't need a response. Motion for bond reduction denied.
Bond denial strikes again. Notice Simpson's tone, flat, final, no need for theatrics. This isn't unusual. Judges often deny bond without lengthy explanations once the factors are obvious: missed court appearances, mental health instability, and prior offenses. For defendants, it's crushing. For prosecutors, it's a win. For us watching, it underscores how swiftly a single motion denied can alter someone's life trajectory. What stands out here is how little debate Simpson allows. He isn't buying excuses of homelessness or missed notices. In his courtroom, accountability comes first. This moment illustrates the cold mechanics of justice. Sometimes it's not about fairness, but about certainty and control. Do you think denying bond in these circumstances is protecting society, or is it punishing someone for systemic failures beyond their control?
Court calls case People versus Taylor Lewis.
Morning, I'm Rob Jacob on behalf of Taylor Lewis. Taylor, would you state your name for the record?
Taylor Lewis.
Thank you.
Judge, I was just appointed this
Oh,
case. We're asking to adjourn the PCC.
Probable cause conference in this matter will be adjourned to February 6th.
Judge, I'm going to be in the middle of, I think my CSC trial is probably going to go most of the,
February 13th.
thank you, Judge. Appreciate it.
No, you don't. 2025, 9
Really do,
a.m.
Judge.
Bond continues.
Oh, Judge, just one quick note. She's a top chef. She's been on tether.
She's what?
She's a top chef at Ford's. She is on a GPS tether. She's only been on it 2 weeks. There's been no violations. It's hindering her work. She lives nowhere near the alleged victim in this matter, and she's asking if the court would please consider. She seems like a very honest woman to me, that she will have
What
no.
way is it?
Pardon me?
What way is it hindering work?
This is one of the most relatable moments in the docket. The defendant, a working professional and top chef, pleads that her GPS tether is ruining her livelihood. She argues it embarrasses her at work, undermining her reputation. The judge listens, but then the prosecution drops the hammer. The alleged crime involves breaking into the victim's home and damaging property. That context instantly reframes her plea. Simpson carefully acknowledges both sides, sympathy for employment, but skepticism about downplaying the charges. This is the tug of war in bond conditions, balancing rehabilitation and livelihood against risk of reoffense.
Because I'm actually kind of the face of my job. All my other employees, everybody works kind of the back. I'm the one that's serving food. So my boss yesterday told me just, hey, it's not really a good look for the company with me walking around with the tether, kind of serving clients of different businesses and different clients we have, dropping off orders that I deal with. I deal with all the ordering and different things.
Response.
Your Honor, we would object to any modification of the bond. Given the facts of this case, the defendant broke into the victim's residence while she was out of town, threw bleach on her clothes and damaged them. Also, stole $350. We feel a tether is extremely appropriate.
Yeah, Judge, again, I'm not to argue the case here. That's just a bunch of baloney. This lady was invited over there. It was a past relationship, and she went over there. The lady told her where to go into the house. Nothing was taken. Nothing was destroyed. She lives nowhere near this lady. She's a hardworking lady. I don't want to lose her job. Would you please?
Well, I don't want her to lose her job either, but I think you're saying she was invited over. That's not the facts that we have in this case.
Judge,
Invitation.
when we hold the exam, there will be texts shown that she was invited over there. She went over there. There was nobody home. She left. All of a sudden now, later, that says this is taken. This.
Well, if you have those messages, I'll consider them, but I don't have them in front of me. I don't have them in front of me at this point. So certainly you can raise that before me, Mr. Killawall, get it to the prosecutor. We'll take a look at it. But at this point, motion for bond reductions are not.
Thanks, Judge. Judge, I will get, I was just appointed on the case. I talked to her last night. She says.
I heard that.
And she said she sent me the text messages. I will forward to the prosecutor and to your honor. And hopefully you'll change your mind,
Your Honor, may I speak or? you
just
know?
real quick.
Am I able to?
I guess he gave my answer. Go ahead.
Okay, sorry. So just really quick, I was in touch with, another attorney, so he was, of course, disappointed to me. My other attorney, I have sent them all the text message proof. She has tried to contact me through everybody else even around.
Ooh,
My ex-girlfriend, we used to live together, and pretty much we used to live together. We had a breakup where I stopped having contact with her. We were actually raising a child together. So she pretty much lured me by blowing up my phone, literally, I mean, every single day up until I went over there saying to come over. for the-
I understand. I may understand all of that.
Yes,
What I'm indicating is that I don't have anything to the contrary of what I have. If you send it off to another attorney, you need to get it from them and get it to Mr. Kilowald
yes,
so he can do what he just said he was gonna do.
yes, sir. I was asking because I live nowhere near this area.
I
So I was
heard that
asking,
also.
yes, am I able to show the messages to him today to be able to show to you today? You know?
I think that if you get them to your attorney will then make the decision as to getting them to the prosecutor and then how to get them to the court.
The defendant insists text messages prove she was invited to the residence, undermining the burglary allegations. This is a pivotal moment. Judges, however, operate on evidence formally presented, not personal stories blurted at the podium. Simpson reminds her, give it to your lawyer, let them handle it, then the system will weigh it. This exchange highlights a key courtroom truth. Self-advocacy often backfires. Courts demand procedure, not passion. For viewers, it's an insight into how truth gets filtered. Even if the texts exist, until they're vetted and submitted, they don't exist legally. That's frustrating for defendants who see their truth ignored, but it's crucial for maintaining order. If you were in this position, would you trust the system to properly present your side, or would you feel the urge to speak directly like she did?
Yes, sir.
We'll do that today.
Anything
Okay,
else?
yes, sir. Yes, sir.
Thanks, Judge. We do appreciate your consideration in this matter.
Yes.
Thank you.
Thank you.
Clerk calls case people versus Ashton Gregory.
And then on behalf of the people,
Good morning, Your Honor. Sam Bernstein here for Mr. Gregory. I don't know that he's present, Your Honor.
Ashton Gregory? That'd be a no. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety.
Failure to appear. This is one of the most avoidable mistakes defendants make, and it costs them dearly. Judge Simpson reacts immediately. $10,000 cash surety bench warrant. No hesitation, no debate. Courts take attendance more seriously than almost anything else. Why? Because if you can't even show up, you signal you can't be trusted on bond or probation, and the consequences ripple. Higher bonds, revoked privileges, longer custody. For viewers, the takeaway is simple. Showing up is half the battle in court. Missing a hearing isn't just a scheduling error. It can redefine your entire case. Do you think a missed appearance should automatically trigger such harsh penalties, or should judges allow more leniency if circumstances are explained later?
Your Honor, I'd actually filed a motion to withdraw from this case based on a breakdown between me and Mr. Gregory, and I think assignment people asked Mr. Kellewald to step up to the plate in my absence if the court would be so gracious as to grant my motion.
Any response from the people?
no objection, Your Honor.
Order for withdrawals granted. Mr. Kilowald, I guess, has been appointed to the case.
Thank you, Your Honor.
Court does call the case of the people versus the Marion Markowski Smith. Markowski Smith.
And then on behalf of the people,
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Mikowski Smith is coming up to the podium. Please state your name for the judge.
Good morning, I'm Markowski Smith. Thank you.
Your Honor, I'm hoping to set this case for preliminary examination. Discovery is complete. I'm also hoping to address bond as well.
Your Honor, we would also include that on the appropriate.
Okay. Surprise. People have their witnesses available on the fourth.
Your bench, Your Honor.
That's my day. Preliminary examination in this matter in person will be set February 4th, 2025, 9 a.m. before Judge Fresh Hour. As to bound.
Well, I don't know what consent as bond argument is going to be. I'm not happy about that, but Mr. Mikowski Smith comes before your honor. He's a very young man with no history of assaultive offenses. He lives at home locally. He works 40-hour week job at Slim's Chicken.
Notice the strategy here: humanize the defendant. The defense stresses youth, steady employment, and community ties, all to counterbalance the prosecution's accusations of tampering. It's a classic bond reduction pitch, but the prosecution undercuts it with evidence of witness manipulation through phone calls, arguably more damaging than the original offense. This is where judges face hard choices. A job at Slim's Chicken shows stability, but coaching family to sway victims shows manipulation. Which weighs heavier? Simpson doesn't hesitate. Bond motion denied, phone privileges restricted. For the audience, it's a sharp reminder that credibility is everything in court. Judges look at actions, not words. If you were deciding, would you let a stable job outweigh phone tampering, or is tampering too big a red flag to ignore?
I know after I'm done speaking, Ms. Senda is going to get up and read the police report, and it might
You
not.
don't know that.
I
Get
have a
with
feeling.
your, go with your.
Okay, okay. Nevertheless, Mr. Mikowski Smith, if the court is gracious enough to consider releasing him, he will go home. He will stay home, with the exception of going to court, going to work, and that's it, Your Honor.
Your Honor, at this time, we will be asking that the defendant's phone privileges be revoked. He's been contacting his mom and telling her to contact the victim, saying things like, I got court at 10 in the morning, they already told me, and if I get convicted, it's a felony myself, but I definitely need to talk to them on that. He also says, right now, today, you gotta let her know, if she, oh my God, when we get off the phone, I need you to call over there immediately. And then he says, you make sure, what's her name, knows not to come at all. Basically, nobody, okay, I'm good. So try to let that be known. Just try to let that be known. So that it's, yeah. Contact the victim through third parties.
And I doubt any of that was in the police report, so she didn't read it. Response.
I have no response here.
Motion for bond reduction is denied. Phone privileges are revoked. You can ask for a hearing if you'd like. Thank you.
Your Honor.
You're welcome. I do what I can. Court calls the case, People versus Hassan Akubar.
Ashley Lonnie for the people.
I said that all wrong.
Yeah.
I know I did, and I say his name wrong every time, but he is so kind that he knows that I'm calling him. So, good morning. Your name, sir?
Hassan, what up?
Hold on while they have a conversation they should have had before I got out here. We'll wait.
For the hearing.
Oh, sorry, Judge.
No, you're not. You just kept going.
That's my fault.
No, it was not your fault. Don't cover for him.
I did not hear you, Judge. My apologies. I was having a spirited conversation with Ms. Lundy.
Is there any other time?
That's what I'm talking about.
Thank you, Judge. This is a case with a substantial amount of restitution. My client is in the process of selling properties. He is asking for one last adjournment. He said if it's not sold by then we can proceed.
This case turns into a financial drama. Restitution of over $130,000 is on the line, and the defense argues property sales will cover it. The prosecution isn't buying it, reminding the court this has dragged on since August with zero money paid. Simpson acknowledges the skepticism but still grants one last shot. This shows his pragmatism. If a lump sum really materializes, victims get restored faster than years of litigation. But it's a gamble. Property abroad, family promises. Judges know those assurances often collapse. Yet Simpson takes the risk, extending until February 20th. For viewers, it's a lesson. Courts sometimes compromise when restitution could actually heal the harm. But do you think giving repeated extensions empowers manipulation, or is it fair if it could finally repay victims?
But he's hoping to be able to pay it all off, Your Honor. He said about 4 weeks. and he
I
said-
know he was trying to sell it the last time.
Yes,
and-
they just came the holidays and and that, so it kind of postponed things and bureaucracy with paperwork and that. So I need one last time, please.
Responsive to people. Because I remember your last time. Because she kept saying, we're never gonna do this again. It's not gonna happen. I remember the whole thing. It's like ingrained in my brain, but go ahead. What's the story today?
Great day.
Yes, it is.
Beautiful day. So for the record, though, we've been adjourning this case for several months. I want to say since August.
Okay.
And the defendant keeps saying he wants to sell property, sell items to pay restitution. I have no record of any request to actually start putting restitution to the court of any kind. And we've been very clear in this case that there will not be a misdemeanor offer. Oftentimes, I know that there can be arrangements made for someone to continue to pay restitution in the hopes of receiving a misdemeanor. We're talking over $130,000, I believe, in this case. We're not in misdemeanor territory. There will not be a misdemeanor resolution. So I understand the defendant wishes to have another adjournment, but unfortunately, there's been no monies paid to the court for restitution. There will not be a misdemeanor offer. So I'm leaving it in the discretion of the court, of course, but I'm not sure we're accomplishing anything here other than just delaying the proceedings.
Obviously, Your Honor, my client has lost it.
Wow. That was very succinctly put.
It was. She's an excellent attorney, Judge.
Oh, she is.
Yes. But
Because she told you this the last time, but you didn't listen. So go ahead.
thank you. Obviously, there will not be payments in this kind of case. It'll be a lump sum if he's able to make the sale of the property. He's not working. He lost his job as a
Is this
result.
real property he's trying to?
Yes, Judge. So this will be a lump sum type of deal. If for a middle ground, if the court would consider.
A middle ground?
Yes, Judge. To move
Oh,
the case
a
forward.
compromise.
Yes, Judge.
Ah.
We can set this for exam in 4 weeks. And at that time, it will move one way or the other if the court is inclined.
Has the paperwork been done regarding the sale of the property? I'm looking at a victim that obviously would need to be restored. And
Yes.
maybe this is the way that it can happen, although irrespective of any plea, I'm not saying that.
Has the paperwork for,
The sale of the real estate, and where are you on that?
Overseas.
Pardon?
Overseas.
this overseas
That's
property?
my other understanding is this is property that's located outside of the United
Yes.
States.
Oh,
Yes,
Which is-
and my family is working on that process and it just, it took longer than I was expecting.
He did tell me that
Yes.
his family has a similar property that they
Yes.
sold last month
Yes,
that would have netted enough to pay the restitution. So he's optimistic
yes,
that this will be sold in 4 weeks and he'll have enough to pay a lump sum and pay the restitution off in full so that the victim in this case is made whole.
give him one last shot at it.
Thank you, Judge.
February 20th, 2025. And bond continues.
Your Honor.
You know,
Yes,
Ms. Lundy's position isn't going to change.
I know, Judge.
So
But-
if you're trying to wear her down, it's not going to happen. I'm just saying,
So, money changes things. Paying off a big lump sum like this.
not going to happen. Telling you right now. It's been before me for years. Not going to happen.
Well, you know it better than me, Judge.
You give it your best shot.
I will. Judge. Thank you.
Court calls the case, People versus LaShawn Courtright.
Ready, Judge. Torshio Feaster, Assistant Public Defender on behalf of Ms. Courtright. When you get here, would you please state your name for the record?
Hi, good morning.
Tell Judge your name.
LaShawn Courtright.
Thank
Good morning.
Thank you, Judge. We did have a chance to meet Ms. Courtright. My understanding in talking to Mr. Durkis is that she has another case at 15th District Court that she is undergoing a competency evaluation for. That has not yet occurred.
Competency hearings again take center stage. This defendant argues she hasn't even received discovery yet, making her feel completely in the dark. Simpson makes it clear first the competency hearing must be handled, then the rest will follow. This is where process can feel like punishment. For the defendant, it's maddening. She's sitting in limbo without clarity on her case. For Simpson, it's procedural necessity. Courts cannot proceed until competency questions are resolved, otherwise any ruling risks being overturned. The tension here is palpable. The system moves at its own pace, and defendants often feel powerless. Do you think delaying cases for competency evaluations protects justice, or does it unfairly drag out proceedings for vulnerable defendants?
So if we could adjourn this out sometime, so that she could have that.
When's that hearing in 15?
Thank you.
26? Thank you. I will adjourn this to February 27th, 2025.
Thank you, Judge.
9 a.m.
Thank you, Judge. And we're gonna call the forensic center to try to help facilitate that interview as soon as possible. I know she's ready to get that done.
Got it.
Excuse me, one day after, sometimes when you get dismissed, that on the 26th, I don't get out to the next day because I'm a female. They won't let me out at night. So for me to get out on February the 26th, I have to be back in court. I won't have time to go over nothing with my attorney. I don't have any discovery at all to even go through with the preliminary examination. That's a little bit too soon.
All right, but we're not setting the preliminary examination. I've just adjourned this proceeding out to the 27th.
What is this supposed to be?
PCC.
Okay, yet still, I have no discovery. I have no idea what's going on with this case. That doesn't
Okay,
give
so
me enough
here,
time.
let's go right here's how it's gonna happen. I'm sure they will get you when they have the discovery. But what has to happen in 15th has to happen first.
I
So I've
understand.
set this the next date. If at that point you still haven't been able to go through everything, I can give you another date at that time.
Okay, thank you.
Okay? All right.
Thank you very much, Judge.
And that brings us to the close of this packed docket under Judge Simpson. Across these cases, we saw every layer of courtroom drama, mental health struggles clashing with criminal responsibility, bond arguments colliding with public safety, financial restitution battles, witness tampering, and defendants pleading to protect their livelihoods. Simpson remained consistent, firm, sometimes sarcastic, but always anchored in protecting the integrity of the process. These hearings remind us how the law isn't just statutes, it's lived drama, with real victims, real risks, and real consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your engagement fuels the channel and ensures we keep bringing you the raw truth from America's courtrooms.